Hello everyone and welcome to today's Mondac webinar in association with Monfrini Bitton Klein, covering professional secrecy and attorney-client privilege in criminal proceedings. My name is Dan Sampaio and I'm joined by a wonderful panel to take us through today's discussion. Before I hand over to Yves to begin the webinar and introduce our panel, a housekeeping item. You are able to submit questions to our panel today by typing them into the questions pane toolbar on the right-hand side of your page. The panel will endeavour to answer as many questions as possible during the Q&A at the end of today's session, but please do reach out if you need a question answered and for any additional information. It's now my pleasure to hand you over to Yves to begin. Thank you.
Thank you, Dan. Thank you to the panelists to join us on, I think, a very interesting topic. So let me start with Azizur Rahman of Rahman Ravelli. Aziz is a UK lawyer and founder of Rahman Ravelli and is a market leader, international legal practice, white-collar crime, global asset tracing and recovery, and commercial litigation. Stéphane de Navacelle is the managing partner of Navacelle in Paris. He practices corporate litigation, mostly in criminal law, regulatory, internal investigations, compliance, complex litigation, arbitration. He's a former member of the Paris Bar Council. He's a bar disciplinary judge and a bar apprentice for influence through law. Nicholas Surmacz is a US qualified attorney in Corbry & Kim's London's offices. He dedicates himself to cross-border matters involving fraud, bribery, and other misconduct. He previously served as a senior member of the Department of Justice fraud section in Washington, D.C. And last but not least, Evin Durmaz is an associate at Monfrini Bitton Klein in Geneva, and she practices in complex cross-border asset recovery, anti-corruption, business crime, and civil and criminal mutual assistance proceedings. So you will find more extensive bios on the conference website, but since we have a lot to cover, I suggest that we attack directly. So why this topic? Why to have a comparative approach to professional secrecy and attorney-client privilege in criminal proceedings? The first thing is that we have different approaches between civil law and common law, and sometimes we assume that things are the same across borders, and actually they are not. And why does it matter? It is because since we as lawyers travel and our documents and correspondence travel, we need to have a better idea and be more aware of how secrecy or privilege will be applied in different systems, so as to be able to best advise our clients and take the course of action that may not jeopardize the confidentiality of our exchanges with our clients. This matter of confidentiality of exchanges between a lawyer and his client is a very old notion present since Roman law, reaffirmed just after the French Revolution in France, in the Assemblée Constituante, and has been over the years under either attack or criticism, either in order to prevent abuses, notably in the context of the fight against money laundering, but also since very often the concept is not well understood, and many persons seem to ignore that this is a fundamental right that needs protection, and it is not for the protection of the lawyers, but rather the clients that this protection exists. So, as I said, we are going to cover a variety of topics and compare the regimes between the US, the UK, France, and Switzerland, and always trying to identify the large differences and the tips and tricks that one may be faced to. As I said in introduction, there are some fundamental differences between professional secrecy in civil law system and attorney-client privilege in common law systems. In civil law systems, professional secrecy is a sort of an absolute notion, and even if a client waives it, the lawyer may not be compelled to testify. Whereas in common law systems, there are a variety of waivers that can take place, and also the scope of protection is more narrow. So, Nick, why don't you present to us those notions under US law?
Sure, thanks, Yves. And sorry, my camera is working at the moment, but it may flip up on and off as we go, so apologies in advance. So I think the one way to set this up, and I'm very interested to hear how Aziz will react to what I'm about to say, which is attorney-client privilege in the United States is essentially written down in law what was the rules in England in about 1700. Basically, the king himself gave these rules to Americans, and we wrote them down, and like we never wanted to change them. So it's strangely like a more pure form of like Victorian law than exists in England, which is kind of funny. So Aziz can tell me if he disagrees with me when he speaks. But so it's a long way of saying it's very similar to the approach in the UK, but the UK's has sort of shifted a little bit more over time than maybe the American system, which is maybe arguably 200 or 300 years in the past compared to the UK. But essentially, here's how it works in the US. It's relatively straightforward in the sense that attorney-client privilege exists if there are communications between a lawyer and a client, which is straightforward. I'm sure the same for everyone else. It covers both hiring private lawyers and also lawyers who work for companies and in-house counsel. The discussions is to keep it confidential, and it's for purposes of legal advice. Communications relating to sort of business advice is not covered. So, thinking about lawyers who work for companies, if part of their advice is legal, but part of it relates to the business, only the portion relating to legal would be considered privileged. Another sort of additional layer in the US is if a lawyer hires an expert, such as an accountant or another agent, for purposes of rendering legal advice, the discussions with those experts, such as the accountants, would be covered as well. There's a second area that is not sort of held as sacrosanctly as attorney-client privilege in the US, which is what's called work product protection. It gets a bit complicated, but generally speaking, if a lawyer is creating something for purposes of a litigation, they write down their mental impressions, they organize documents in a way for strategic reasons, all of that would be considered work product. And for the most part, that would be protected as well. However, there are ways for that to become unprotected in certain situations. But I think that the bigger area to talk about, and I think that will differ from what you hear from the continental lawyers, is the exceptions to the privilege in the US. There are a number of different exceptions that essentially will vaporize the privilege, for lack of a better term. So the first is a waiver. In the United States, if a lawyer gives you legal advice, then you tell your friend about the legal advice, you have waived it, and the protection over all the advice is gone. So that's really important to think about. In sort of a corporate setting, another way to think about it, if the legal advice is shared with, for example, an auditor for purposes of a financial report, then that advice is considered waived. I'm not trying to scare everybody, but it gets even worse, because if you have received a 100-page memo of legal advice and you decide that you want to share one page of it with people on the outside because it'd be good for you, courts in the US have said that you can't do that. That's considered a selective waiver, and you've essentially waived the whole 100-page memo. It does get complicated, but I think it's an important concept to know for people who don't practice in the US often, is basically if you waive some of the advice, it could be deemed that you waived all the advice, and it could be used against you and given to the other side in the litigation. A couple other just quick other exceptions that are become important. There is one that they call company has the privilege. There are ways for you to get at privilege information in the company if they are your fiduciary. And another one that we'll probably talk about later is the crime fraud exception. essentially, if a client uses legal advice in order to commit a future crime or fraud against someone else, that legal advice would not be considered privileged. It makes some sense, right? You can't use a lawyer in order to commit an offense or to defraud someone else. And that applies even if the lawyer didn't know that that's what was going on. They thought they were giving genuine advice. That doesn't matter. The advice would still be considered waived. And even though there's one other thing you wanted me to cover, then I'll hand it back to you. Another thing to think about in the US is,
Nick, I think we'll, for the interest of time, we'll now pass on to Aziz, who will chime in on.
Okay. All right. Well, look, thank you very much, Yves, for inviting me to be part of this panel. As in your jurisdiction and similar to the position in the US that Nick has just pointed out, privilege or legal profession privilege in the UK is a fundamental common law right, and as Nick says, dates back to the 1700s century. It protects individuals and companies from disclosing certain types of confidential documents to authorities or an opponent in litigation. So as in your jurisdiction, the privilege is absolute, as Evin will be discussing later, and can only be overridden in very exceptional circumstances. Nick has gone through some of those circumstances, and broadly, the position in the UK is similar. As in your jurisdictions, and it needs to be stated, I think, that no adverse inference can be drawn when privilege is relied on. The privilege belongs to the client and can only be waived by the client, and the lawyer has a professional duty to assert the privilege. Now, in the UK, privilege falls into two separate categories, and the distinction is quite important because of what we're about to discuss later. So the two categories are legal advice privilege and litigation privilege. Legal advice privilege essentially covers communications between a lawyer and their client, which is created for the dominant purpose of seeking or giving advice. And the latter, litigation privilege, covers communications between the lawyer or the client and a third party, provided that such communications or documents were created with the dominant purpose of being used in connection with actual or pending litigation, or contemplated litigation rather. So the contemplated proceedings must be adversarial, and this is important because there have been a few developments which I'll come to later. And the contemplated proceedings must be adversarial in nature as opposed to inquisitorial or investigative, which is also important, and they must be reasonably in prospect. So basically, two types of privilege, one that belongs essentially to the client, and one which is to the client or another party, or the lawyer and another party. And what's important in the UK, and we'll talk about this later, is in a corporate setting, who is actually the client? Because in a modern corporate, you have different streams of governance and management. So in a corporate, the corporate itself as a whole, and employees per se are not the client, but a specific group within the company that are authorized to receive and seek legal advice is considered to be the client, and that's where litigation, legal advice privilege kicks in. Going on to talk about waivers, the situation is pretty similar, although probably not as harsh as it is in the UK, in the US rather, Nick. But when it comes to waivers, there is a concept of limited waiver where you can disclose documents to another party on a limited basis. That doesn't in itself mean that you lose privilege over the whole of the document. And then, of course, there are similar situations as Nick has mentioned with the crime, fraud, exception and iniquities. So that's
Thank you. Over to you, Evin, and then Stéphane. Are you shocked by what you hear? Of course, you know each other already, but how fundamentally different is it from the protection in Switzerland and France?
Stéphane, maybe I start with Switzerland.
Please do go ahead, and I'll follow up to the extent needed.
Yeah, so it's very interesting because the way that even you describe privilege in the US and the UK is very different to what we would start by describing in Switzerland. Because for us, what is very important in any case, so it starts with this, is that professional secrecy, so that's how we call it, and that's how you translate it into English, is a cornerstone of the rule of law. So that's why it's they tend to call it absolute. You will see, and especially with the explanation that we will give today, that absolute is not really the correct word given the number of exceptions and things that need to be kept in mind. But in general, in Switzerland, all typical activities of lawyers are protected. So I'll go into more details about what is a typical or an atypical. That's how we define the two in Switzerland. Activities are divided, but I would say anything that the word typical brings to your mind is covered. So any representation, advisory type of work is covered by attorney privilege. What is more interesting, so if we don't go into details of what it is exactly, but what is very interesting is how it's protected in Switzerland, because it's anchored, I mean, in the constitution indirectly, but also in all types of various laws. So that's also quite different from the common law system, where we have it in our procedural code, in all different codes, how it's protected. One aspect that I want to say that the two aspects that are very important to understand is that in Switzerland, violating professional secrecy is a criminal offense. So we have an article, it's 321 in our criminal code that says that if you violate your secrecy as a lawyer, it's considered a criminal offense. And that is very important because most of the time when we talk about protecting, what do we protect and how it's protected, we go through this criminal law. And then we have a second article that's very important, that's in a law, and bear with me because the title of the law is odd, but it's very important. So the law is the Federal Act on the Free Movement of Lawyers. And why am I talking about free movement here? It's because when Switzerland was negotiating bilateral treaties, they realized that they had no federal rules about lawyers in Switzerland. So this law initially was to say that how European lawyers could work in Switzerland. And then the legislators thought, okay, that's great. That's the perfect law where I can also add all the duties of lawyers. And that's where the professional duty, the duty of lawyers to keep professional secrecy is written. And it's very important because, as I said, the criminal offense is for all lawyers all around the world. If you're a lawyer and you're in the territory of Switzerland and you violate your professional secrecy, it's a criminal offense. If you have a European lawyer acting in Switzerland, a Swiss lawyer acting in Switzerland, on top of that offense, you also have a violation of your duty as a lawyer in Switzerland. So these two things, what they allow you, I mean, these two articles, they give you more or less the same protection, which is that not only a lawyer cannot spontaneously provide information about a mandate that she has, for example, but also a lawyer can oppose to any request from authorities to provide information. So this is absolute in the sense that then there are exceptions to why we oppose, but most of the time we can oppose against authorities not to provide this information. And then the last point that is, apparently it has changed in France, so I'm really interested to hear Stéphane talk about this, but in Switzerland, you can be released of your secret. So we don't have all the waivers that are very scary like you have in the US, but you can have your privilege waived by your client or by a supervisory authority. But you can still decide as a lawyer to remain silent, and even if you have been released by your client, not to provide this information.
Thank you, Evin. Stéphane?
Thanks, Yves, and Evin. I'm excited to hear about the atypical activity of lawyers. I understand what a typical lawyer does, but an atypical lawyer in Switzerland is sounds exciting, at least. I'm going to keep it short because it's really very similar rules. You know, in a nutshell, the attorney-client privilege is between a member of the bar and his or her client. And the way the idea of a member of the bar in France works is it's someone who is an outside counsel. So if you move in-house, you have to have yourself removed from the bar. There is no such thing as privilege for in-house counsel in France, and that's something that repeatedly comes into debate when you're dealing with cross-border matters or cross-border companies. People feel that they are safe because they're writing the in-house lawyer. In effect, they are not. With respect to communications between lawyers, most of you are probably familiar with the idea of joint defense agreements, written or oral, and so on and so forth. The rule in France is slightly different in the sense that any communications between two lawyers is confidential by nature. And the idea is that similarly to the fact that in the UK, I think in the US, lawyers are officers of the court. In France, lawyers are auxiliaries to justice. And the idea is we sort of serve a greater cause, and it's important that we can speak together freely. So in effect, you have to write official on the document itself for the communication not to be privileged. And even so, you can only use that in a certain number of cases. So you can easily speak to lawyers on a matter, and that will stay confidential. Maybe two caveats to that, and I think I'll speak about the law a little later on in our conversation, the new law from late last year. Two small caveats. One is when the lawyer, him or herself, are at stake and their responsibility is put into question by a client, and that's the one exception, then the idea is that the right of the lawyer as a defendant should not be impeded. And so the client can go to the press and say, you're a horrible guy, a terrible lawyer, and so on and so forth, and there's nothing you can do. But if the client takes you to court, then you are authorized to disclose the information that you have exchanged with the client. One last exception, probably less relevant for our panel today, is when you are in a situation where you encounter someone who's potentially a victim of sexual assault or mutilation, and that person is either a minor or in a physical or mental incapacity to do something about it. So that's a very limited situation, which doesn't fit probably most of the white collar matters we're talking about now. And I'll talk about the December law, I think, later on in our conversation.
Thank you, Stéphane. So we have now already seen a lot of differences between our countries. The next question is who is a lawyer, and we've addressed already that in-house lawyers may or may not be considered as lawyers from the perspective of confidentiality. But how does your law, your admission to the bar, travel from one country to the other? Evin, I believe we have had some recent case law on which you wrote an article last year.
Yes, no, it's a simple question: who is a lawyer? And in Switzerland, this simple question became quite a complicated, fact, especially with regards to criminal proceedings. I would say what I'm explaining, and I'm going to keep. I see Yves pressing us with keeping our answers short, so I'll just focus on criminal proceedings. So, who is a lawyer is very important in the context of foreign lawyers, because in Switzerland, what really is quite common, especially in our practice, and I know the practices of my co-panelists as well, it's very rare that you have a case that's only with one aspect and in one country. You have a piece in the US, a piece in the UK, a piece in the Bahamas, a piece in France. So the way that you have to handle your data and what it means to be a foreign lawyer is very important in that really specific moment. So in Switzerland, as I explained, you have these two ways that professional secrecy is protected. You have the criminal law aspect, as well as this regulation that's inside the free movement of lawyers aspect. For most of cases, for example, for examinations of lawyers in Switzerland, if you are a lawyer and you need to be examined in a criminal proceeding, we also have the exception of the case where the lawyer is a suspect himself. I'm just going to ignore this. But if then you take the word a lawyer that needs to be examined, in that context, the article refers to the criminal law, so Article 321, which means that all Swiss, European, and foreign lawyers can invoke the professional secrecy to refuse to be examined in a criminal proceeding. So that's great. That's one of the moments where we're very happy, because it means that if you're a foreign lawyer according to your own jurisdiction, then you can invoke this in front of a Swiss court. However, there is a little bit of a less straightforward situation. And I know Nick is always shocked by this, so I'm a bit, as his camera comes in and out, so we'll see his surprised face very, very soon. But it's with regards to the seizure of documents and to the access of documents from prosecutors in criminal proceedings. Because the law changed, we had a change of law, and the point of the change of law was coming from a good intention, but with a lot of good intentions didn't come a very good delivery. Because what happened is that the legislature created a distinction between a suspect and a third party with relation to professional secrecy. So if you're a suspect in Switzerland and in a Swiss proceeding, and there is a raid in your office, or there is a raid in basically your stuff is seized at the airport or anything of the sort, as a suspect, all your correspondence, your documents, the information, the data that is protected, that's what we call the typical activity, and we'll come later, Stéphane, I promise, to what it means, is covered, and the prosecutors cannot have access to this documentation. It's removed, and it needs to be removed, and there is a process of lifting and protecting this data. However, if you're a third party to the criminal proceeding, and that's very important to understand, what is a third party? It can be if you're a witness, if you're a plaintiff, but also if the prosecutors have decided that you're a person of interest, but you're not yet to the level that you're a suspect, your protection is different. Your data, the information that you have, your correspondence with your lawyers, then the reference in the law is not to the criminal article that the criminal law that I was mentioning before. It's a reference to the Federal Act on the Free Movement of Lawyers. So that means that only lawyers that are lawyers under the Free Movement of Lawyers Act are protected, and only their correspondence is protected. So Swiss lawyers, European lawyers have their correspondence protected. I will say now, before Aziz drops, that Switzerland and the UK have now a bilateral treaty, and there is an extension of this law on UK lawyers. So basically, it's very important to understand that only Swiss, European, and by extension, the UK lawyers' correspondence, documents, work product that are protected. So if you have a proceeding in Switzerland with someone that is not yet a suspect, that might be a suspect or a plaintiff, then if your American lawyers from Cobra and Kim, for example, they exchange with the client, this document during a raid can be raised, they can be seized, and they can be looked at by prosecutors. And that's something that I don't think the legislature intended, but it has unfortunately been confirmed by the federal court, because that's the way the law is written. So they just said, it's a bit unfortunate, but that's the way it's written. So I really have a tip. We wrote an article about this last year. It's a very important tip. It's not because I think it's very smart, but I think that it's important to have always European or Swiss lawyers in copy if it's important, and especially certain work products, especially in terms of internal investigations and certain documents that are very important, that you really know that there are Swiss proceedings open, that you want to keep protected, to have Swiss lawyers or European lawyers or UK lawyers in copy of these emails. I hope it will be corrected one day, but for now, that's the way it is.
Thank you. Stéphane, how is the situation in France, contrary to any of our countries, is a member of the European Union?
You know, I have to confess, I don't know that we have rules of the Brits as of now, but there may be something, a deal that we're getting to at the EU level. In a nutshell, the rules of relating to privilege apply for all EU countries, and as a sort of a blanket situation. And any EU lawyer can be an attorney of record in French criminal procedure. So that's, you know, that's really where we are. What I would like to do now, if that's okay, is really talk about the limitations of this new law from December last year, which really narrows very much the scope of attorney-client privilege when you are in the context of a criminal investigation. And what the law did is it reinforced the scope of privilege, but in the aftermath of a number of international, especially tax-related fraud, the legislature decided to basically include exceptions in certain fields, and unsurprisingly, those fields are those which keep us mostly busy, because that's where all the sort of white-collar criminal conduct is alleged. So it is investigations into tax fraud, corruption, or the laundering of the tax fraud or corruption, as well as terrorist financing. And so if the purpose is to establish the proof of the use of documents to commit or to facilitate the offenses, then the documents could be looked into, and you will read here you will hear that this extends to legal advice, correspondence, documents held or transmitted between an attorney and his client or her client, establishing the proof of the use for purposes of committing or facilitating the offenses mentioned. So it doesn't even need to be something that is committed by the lawyer himself or herself, but by the client. Now, because the lawyers were generally unhappy with this, important caveat, the decision was taken that there would be a specific judge, which in French is called le juge de la liberté et de la détention, who basically is a civil liberty judge, if you will, who reviews the document and not the judge or the prosecutor investigating the case. That being said, given the fact that there is a judge that reviews the documents to determine whether or not they fall under the exception, it makes this independent review to a very large extent moot. And I think that's extremely worrisome and should be kept in mind. Of course, this is a few months, we're not even a year into the law, so we don't have case law yet. But the bar is very, very focused on that, and the bar representatives involved in litigation relating to the exception and so on.
Thank you, Stéphane. Let's jump on to something that has intrigued you, which is the difference between typical and atypical activities of lawyers in Switzerland, and more broadly, the exceptions to secrecy provided by the anti-money laundering regimes. Evin?
Yes, that's a subject that's taking a lot of space. I mean, in Switzerland, especially because our bank is situation, very often it comes to Switzerland, is anti-money laundering situation. So I think I've kept the suspense for long enough. What we call typical and atypical activities is, according to the case law, typical is representation advisory, and that's how the federal tribunal sees it. And then it's been developed by the doctrine how you can define what's an atypical act, and it's basically you define what's typical and then the rest is atypical. And another criteria that we have is what is, they say, is this activity allowing you to have access to the law or access to justice? If you say yes, it gives you access to law, to justice, it's a typical activity. Then the rest is not. But then if I can give you a few examples, you have purely commercial activities that are not. So if you can give advice on how to structure a company, that's a typical activity. If you then file documents to the registry, the commercial registry, that's an atypical activity. If you act as a director, it's an atypical activity. And so what the federal court says that you can have also mandates that have mixed nature. So certain types of your activities, for example, with the structuring of a group. So the advice that you give, the explanation with the pros and cons, that's a typical activity that's protected. And if you provide, more the administrative stuff to create the company, that's atypical. So it's very important to distinguish between the two. And it's especially interesting because there's a lot of case law about anti-money laundering. So if you're acting, and that's another atypical activity, a financial intermediary in Geneva, I think it was a bit of a specialty. We have a lot of people that act as lawyers that act as financial intermediaries. Then you have to respect anti-money laundering regulations. And it even goes to the point where the federal court said that a lawyer that is acting as a financial advisor or an intermediary needs to report suspicious activities to the money laundering reporting office in Switzerland. So it seems a bit odd with regards to secrecy, but if you really need to think of how and what you're doing to be sure that you're not violating anti-money laundering regulations. So it's a bit similar to what is happening a bit in France. So I would say as advice again for everyone is when you act and you know that you're acting from abroad, but then there are consequences in Switzerland or you have Swiss lawyers, is to always think, is this a typical or atypical activities? And if you have AML requirements under Swiss law that needs to be respected, even as a lawyer, you need to respect those and you cannot use secrecy to avoid those.
Thank you, Evin. Aziz, can you briefly address how the situation is in the UK regarding suspicious transaction reports, and then more broadly under what circumstances a lawyer holding information may have to provide them, for example, if in case of a Section 2 notice?
Yeah, absolutely. So the position in the UK where there's a duty to report as far as AML concerns depends on whether you're in the regulated sector. So very similar to what Evin has just said. So very, very broadly, law firms in England and Wales that provide financial, real estate services, trust, company services, or tax advices are bound by the money laundering regulations and under duty to report suspicious transactions, where generally there is a reasonable suspicion that funds may be the proceeds of crime. Criminal law firms and firms carrying out non-regulated work are not in the regulated sector. So even so, despite them not having a positive duty to report suspicious transactions, they are encouraged to report such occurrences to the regulator. Now, you asked about Section 2 notices, right, Yves?
Yes.
So as far as Section 2 notices are concerned, a Section 2 notice is a notice issued by the director of the Serious Fraud Office, which is the premier business crime agency in the UK, basically requesting documents and/or testimony from the recipient. I suppose the British equivalent, it's the British equivalent of an American grand jury subpoena, Nick. So provision in Section 2 specifically exclude documents which the recipient would be entitled to claim legal privilege. Section 2 notices can be deployed against lawyers, and there have been a number of cases, including a very well documented one recently. But it is rare, unless of course the lawyer is a suspect or the crime fraud exception applies. So it should be noted, however, though, that Section 2 powers don't have extraterritorial effect. So in the recent Supreme Court case, it was made clear that ISFIL couldn't use Section 2 to force a company to hand over documentation held abroad, adding that the UK Parliament hadn't intended for Section 2 to be used in that way. However, Section 2 powers continue to be used against individuals and companies, and as I say, it's very rarely used against lawyers. And of course, you have to exercise caution when you serve with a Section 2 notice.
Thank you, Aziz. Nick seems to have disappeared again, so maybe if you can.
I can't hear you, Eve. It's
okay. Sorry.
My computer and I are not friends today, I think is what's happening.
Okay, so under US law, under what circumstances must a lawyer actually report his client to authorities? We're not talking about subpoena, but AML or other instances of.
Yeah, so the US is a bit of an outlier jurisdiction on this. Generally speaking, there's no requirement for a lawyer to report their client to anybody legally. Like there generally isn't like a criminal statute that penalizes a lawyer for not doing that. But the state bars that regulate each of the lawyers, so I'm a member of the New York State Bar, have ethics rules that require you to report certain types of crimes, but it's much more narrow than the things that the rest of you were talking about in your jurisdiction. So in the US, essentially there needs to be a credible threat of harm to someone else. And most states basically say that you have to know that there's going to be like death or serious injury to somebody, and then the lawyer has an ethical obligation to report that to the police. In some jurisdictions, that's been interpreted to also mean financial harm. So if you know that a client's essentially committing an investment fraud scheme, and unless you say something, people are going to lose money. Some state bars have said that also applies. I think in the US, how it normally works is that if something like this is going on, they have specific ethics advisors that each of the state bars have, and the lawyer sees them and said, here's a situation, what do I do? And I'd say the most natural result of these is usually the law firm just quietly withdraws from the engagement, and they're no longer representing the person. And if they have what they think is a required reporting obligation, they'll make that. But then otherwise, people will sort of see that the firm has withdrawn. I think the most classic case of this in the US is if somebody is going to testify in a court proceeding and the lawyer believes that they would be committing perjury by knowing what they're going to testify to, the law firm essentially has a duty to withdraw from the engagement, and the judge is required to sort of let them withdraw. You're not supposed to say the reasons, but it's pretty clear to the judge anyway what's going on. If the law firm says, my client would like to testify, also I'm not their lawyer anymore. But that's sort of how it plays out in the US. So it's much more narrow, and there are only sort of very limited circumstances where a lawyer has a duty to report a client, and it's usually in the case where there is sort of a credible threat of harm to other people.
Okay, thank you. Let's move on now to internal investigations, because in several of our countries we have specific case law providing again exceptions to confidentiality in those cases. Aziz?
Yeah, sure. Thank you, Yves. So from a UK perspective, the law relating to the status of documents produced as part of the internal investigation as to whether they're covered by privilege or not has been the subject of intense debate, as you've just mentioned. Indeed, we saw a position in England and Wales in the case involving the SFO and the mining company ENRC in 2017, casting doubt over the category of material that ordinarily and otherwise you'd expect to be covered by legal professional privilege in some way. As I mentioned earlier, the position turns on whether legal advice privilege applies, in which case only documents between the group classed as the client and the lawyer will be protected, provided the dominant purpose, as I've mentioned, is seeking and receiving advice. And secondly, there are a number of considerations to be taken into account when claiming protection under the legal litigation privilege sphere, in which case adversarial proceedings have got to be in contemplation. So in the ENRC case, the SFO sought disclosure pursuant to Section 2 powers, as I've mentioned earlier, which allows the SFO to request documents from a recipient. The SFO sought, amongst others, and importantly for us lawyers in the panel and in the audience, notes taken by lawyers of the evidence given to them by ENRC's employees, former employees, subsidiaries, suppliers and other third parties. And secondly, material generated by forensic accountants as part of a books and records review. As I've said, ENRC claimed privilege over these documents, and the first instance judge rejected all but one of ENRC's claims. She held that legal advice privilege didn't apply, as the parties subject to the interviews couldn't be classed as the client because they weren't in that specific group following a case. And litigation privilege didn't apply. Strangely, the judge said that the SFO investigation wasn't sufficiently adversarial, and it couldn't be said that litigation was in contemplation. So, to the relief of many, we're pleased to hear, especially in England and Wales, the decision was overwhelmingly overturned on appeal. The Court of Appeal held that interview notes and accountants' reports were protected by litigation privilege, as criminal proceedings against ENRC were reasonably in contemplation when ENRC was contacted by the SFO. It didn't, however, interfere with the principle that there is a restrictive definition of the client. So that issue pretty much stays with us. So in terms of an internal investigation, it's important that you embark on this with a view to maintaining privilege in the documents as much as possible, to the extent possible. I'm going to go through just some minor tips, if that's okay, Yves. So in an internal investigation, you ought to consider the issue of privilege from the start of any possible legal issue. It can't be attached retrospectively. You should seek specialist lawyers ASAP to maximize the protection privilege can provide. Normally in internal investigations, it's sensible to utilize external lawyers, and I know probably in France you will have to use external lawyers because internal lawyers don't attract privilege. External lawyers have better resources, usually expertise in the field, familiarity with the regulator or authority, and importantly, independence. From what I've said about the legal advice privilege and who the client is, in England and Wales, when you start an investigation, internal investigation, particularly important that you identify who the client is. You should clearly document that at the outset, preferably in the engagement letter. And I know there's a similar situation in France where, let's say for argument's sake, you wanted to speak to a member of the family, then you ought to add the member of the family in a retainer. So similar type of situation. You should, of course, have clear lines of communications both internally and externally. Finally, businesses should be able to demonstrate when you're talking about litigation privilege. So, for example, when the lawyers are talking to people that are not considered their client, to be able to assert that civil litigation or criminal prosecution is reasonably in contemplation. That will make asserting privilege easier.
Thank you, Aziz. We'll change subject, unfortunately, for maybe in the Q&A we can address again the issue of investigations in Switzerland, the US, and France. Stéphane, let's pass now to the next topic, which is professional secrecy when the lawyer is a suspect. How are those things addressed in France? We all recall of a famous case about former President Sarkozy.
Sure. So the case you're referring to is, basically an investigation by the prosecutor into other prosecutors on one hand, and an investigation from the same sort of financial prosecutor's office in Paris, which is always very nice for the morning coffee with your colleagues. And there were two sort of separate issues regarding Sarkozy. The first one is they realized Sarkozy was speaking to his lawyer, and they came to a situation where they realized that it was likely that they were being tapped, and Sarkozy or someone for him, I don't know, opened a separate line under the name of one of his buddies from kindergarten, and they used that phone to speak with the lawyer. Now the investigators figured it out when they started having a conversation on the phone that was tapped, and they said, I'll call you right back, and he never calls back. So obviously there was another line somewhere. And very surprisingly, the courts have said that the investigators could tap this separate line because it was not obviously Mr. Sarkozy's line, because it was under the name of someone else. Now that's of course extremely disconcerting when you think that a line which its sole purpose is to speak to your lawyer is the one being tapped. And there was a second matter where the investigators were looking into leaks, and who was leaking information in this sort of corruption / political matter, and they were trying to figure out who was going into the offices of one of the lawyers, and they used the triangulation of phones to see who was staying more than a certain number of hours in a given law firm. And who they were really looking for there is a potential prosecutor or a judge who was sort of potentially leaking information. Now, that has received huge criticism. I think it's also fair to say that it is to some extent, politically motivated. And I don't think that those cases are likely to occur in a situation where people think rationally, but it did happen, and it was considered in both those cases that the wiretapping and the triangulation were appropriate, and that is of course disconcerting. When it comes to investigating lawyers, because we have this principle of the professional, the attorney-client privilege, the professional secrecy, as we call it. If you are to raid the offices of a lawyer, the investigator, the judge, so the judge or the prosecutor, have to let the president of the bar know and the president of the bar will send someone who will literally be there during the search, the dawn raid. And so basically you go to the office of the home of the lawyer, and you pick him up, and then you take him to his office, and the representative of the president of the bar can challenge the seizure of documents, and the challenge goes to this judge I mentioned before, the judge of freedom and of detainees, juge des libertés de la détention, to determine whether or not the document was properly seized. Now, as I've said previously, and you've all can imagine easily, once the judge has read the letter or the document, it's very difficult to delete one's memory. So I think it's always a bit of a tricky issue, and I like what appears to be happening, at least in the US, where you really use a third party which is completely fenced out from the investigation itself. Or I hope I got that right.
Nick?
Yeah, happy to jump into that. So, Stéphane, I think you're right. I think the issue in the US is that typically only happens in very high-profile cases where the parties have resources, because the special master is not a court officer. It's somebody that's sort of paid for by the parties in order to take on that task. So let me maybe back up and sort of talk about sort of how it normally works in the US and why I think there's now a pattern towards going to special masters, because there is a problem in sort of the typical way it's been happening in the US, and courts have become more and more upset by some of the things that have happened. Because generally speaking, when there's a raid in the US, it's not as civil as it is in each of your countries. It involves about 20 to 30 men in windbreakers and lots of guns. Usually only 2 or 3 of the agents that do it are on the case and know the facts of the case. And then they bring in all their friends on a raid day, and they all get to go in and be FBI agents and go in and like take everything. The problem is, because only 2 or 3 of them really know the case, they're going through just massive sets of records. It's impossible for them to tell if something's privileged or not from the face of it, right? It's impossible. Even if people are really well trained, right, and know the case. The issue is that lawyers, once the FBI goes in and does a search in the US, they put up a perimeter, it's just like TV, everyone like stands there, there's all the cars and the big trucks and stuff, but lawyers aren't allowed in. If it's my house and they're searching it, I get kicked out. I can tell them, hey, there's privileged stuff in there, but they don't let you in, generally speaking, and they just do their thing. And then when they're done, they're like, here's your receipt, here's all the stuff that we took, thanks, right? And how it normally works in the US, in a typical case, is that if the lawyer informs the FBI and the prosecutor, the DOJ, hey, privileged stuff was taken, they say, thanks, we got it. It's literally what happens. And what they are supposed to do is implement what they call a filter team, which is a prosecutor that has nothing to do with the case and agents that have nothing to do with the case. So in the FBI and in the DOJ's mind, it is independent. But Stéphane, I'm sure you'll point out, they still work for the government, right? So they're not independent in sort of a true sense of it. They're independent from the case, that's true.
Yeah.
And their job is to look at it and decide if it's privileged or not. And they can choose to engage with the defense lawyers. Some of them do, but sometimes it becomes very adversarial and they do not. And they sort of make a unilateral decision about whether or not something's privileged or not. And look, they're not always right. I mean, they do their best, right? I mean, for the most part, this process actually does work in the normal case, it does work like this because of resources. It's sort of the only way to do it. And documents that are clearly privileged get set aside. Ones that clearly aren't are sent to the case team. And you can bring a court in on certain documents, but normally speaking, they sort of engage in self-help. And what ends up happening is mistakes are obviously made because we're talking about lots and lots of documents. And the defense usually only finds out once the person's charged and they get discovery and they say, why does the case team have this stuff that's all privileged, right? And the remedies in the US courts are generally, in like the worst case, the people who saw the document, like you said, you can't unread something, are forced to go off the case and they bring in fresh bodies to try the case, right? That don't see these documents. But that's usually sort of the worst thing that can happen. In sort of the very, very rare case, if there's like gross misconduct and bad faith by the government, the case could get dismissed. But like I did research, I think it's only happened like 2 or 3 times ever in the history of the United States. So it's like, that's not gonna happen unless you just get a crazy situation. But courts are becoming more and more skeptical about this process of the DOJ doing it themselves, especially if there are when mistakes happen. So that's why the special master system has come in place. And obviously it's very high profile now because President Trump has sort of demanding that. His is a bit different situation because he's talking about sort of personal information plus executive privilege, which is like a totally different topic than what we're talking about today, right? But I think one important thing in raids in the US, like anywhere, right, they have a document saying, here's the stuff you're authorized to take. One of the things that always happens in the US is they take stuff that's not on that list, right? Or it's sort of an email search warrant, right? You get the whole email box, but you're only allowed to take things that are relevant to a certain thing. And that sorting is like never really done. Often, but I'm not gonna be fair. Sometimes it's not done appropriately, right? So then you have like a second problem where like the discovery comes like, why do you have all this stuff? You never were authorized to take it in the first place, right? So that's the other thing that's going on in the Trump situation. So I agree, Stéphane, it's a really good idea. I just don't know how given sort of how the finances work in the US. And if you get raided and you don't have a lot of resources, it's probably not gonna be available to you, right? So it's just, that's the system that the US has. And I think it's so different than each of your systems. And I'm not here to say the US one's better. I think there's a way to maneuver in it and it can be done fairly if done right, but there are obviously a lot of issues, which is why sort of the special master thing has sort of taken off recently.
Yes. Yves, can I have a quick follow-up?
Sure.
Just want to, in France, any civil servant has an obligation to report a crime. So, and that's a big problem that we have, for example, with the anti-corruption agency, where if they see something, and any multinational company has a problem somewhere at some point in time, then they're under a legal obligation to report to the prosecutor. Is that something similar like that in the US? No, okay.
We have it too in Switzerland. Just getting back to the issue of...
Can I ask one follow-up question talking about internal investigations? Because on that topic, I've seen in other countries where oftentimes you have a legal obligation to report a crime within like 24 hours of finding it out. So how does that play out if you're doing an investigation for a company? You think a crime may have been committed, but you're not sure, and then you think it was committed by somebody and you're not sure, but then you have this legal obligation plus privilege. Like, it just seems like a huge mess to like maneuver to make sure you're following the law, but also protecting your client at the same time.
It's a huge mess, yes.
Yes. So what we are seeing also in general is that the safeguards that were put in place in the past when raids actually were targeting paper documentation work less and less in the raiding of electronic data. And what is important, I think, to discuss now are the remedies through which once a trove of electronic or paper documents are seized during a raid, how is privilege or professional secrecy protected? What are the mechanisms in place and the authorities? Aziz, do you want to begin on how the process is
absolutely. Yeah, so powers of seizing material are contained in statute, but you're not allowed to seize privileged material. That's specifically excluded. However, when you can't tell what is privileged and what is not privileged, then a warrant usually allows you to take everything and then apply a filter process similar to the filter process that Nick mentioned that happens in the US. So nowadays, the practical points that we're dealing with essentially, as you mentioned, is in relation to digital data. And when a decision, let's say by the SFO, can't be made at the time of the raid as to whether an item in question is privileged or not, then there is a protocol in place for the SFO to deal with that material. If we're talking about the SFO, that is, different enforcement agencies have differing rules, but they all have the same foundation. So essentially nowadays, what you find is that the material is loaded on a platform, probably similar to the US. You apply search terms. The defense are given an opportunity to provide search terms to the technical team, and of course, the important issue that I should point out for the UK or England and Wales is that once those privileged documents are quarantined, then either it's court appointed or is agreed that independent privilege counsel will review those documents. So you have a situation whereby the internal technical team at the SFO quarantined the document, and that's been held to be okay, even though they're not independent. And then you have a situation whereby an independent member of the bar is usually an independent member of the bar who looks through the document and decides whether those documents are privileged or not. If they are privileged, they're returned. If they're not privileged, then they're passed on to the investigation team.
Thank you.
So that's
Evin, sorry. So it raised a question also of resources, and Evin, can you tell us about the situation in Switzerland?
Yes, maybe if you, I'm going to do a 2 seconds of gossip following up on what Stéphane was explaining on the Secrecy case. We also have a equivalent of that case in Geneva, and it's been a big scandal where there was a few suspects, real estate promoters that were suspects in a criminal investigations, and their phones were bugged as well. And then instead of just going through the process, I will explain now. What the police has done is that they've transcribed all the conversations that lawyers, all the conversations between the suspects and the lawyers. And then all these conversations were then filed in the criminal file. And it turned into this gigantic scandal. And now, this topic is like the hottest topic in Geneva, and people are just asking for the prosecutor to be recused. And the case is much more political than it was. So it's not Sarkozy, unfortunately, it's not as gossipy as that, but it's become a big subject here because I think it was also a bit surprising. Most of the older lawyers were not surprised that the phones were tapped, but for the rest of us, we're a bit surprised. But yes, how does it work in Switzerland? So what the police should have done was, usually if you raid a place, that can be a law firm. If it's in a law firm, you also have the bar, like in France, you have the president of the bar association that comes. But usually when you raid a place, as lawyers, we tend to ask them to take only what they really, really need, which they don't do. And we end up with a gigantic amount of data. And these documents are usually put under seal. That's how we call them. This is what we ask as lawyers. We usually recommend our clients to put all the documents under seal. And then the prosecutors have 20 days to request the lifting of these seals. And the competence for reviewing it, it's a bit like in the UK with the independent lawyer. And it's not, I don't remember, it's the Tribunal de Liberté de la Détention, I think that's how you called it. We have also one that's similar, it's a coercive measure tribunal. And the sorting process happens in front of this coercive measure process. And talking about resources, we have federal cases that end up in tiny little tribunals, and they just don't have the resources because you end up with, hundreds of folders and binders, which is paper, and it takes days of reviewing it. And what's important, and that's something that we tend to tell our clients as soon as an investigation is open, is to anticipate a raid and separate already what is protected and what is not protected. And what happens is that you need, under Swiss law, to give a reason, and there is an obligation of the owner of this data to provide explanation for each single page of whether something is protected or not. And you also have this obligation for emails and electronic documents. So of course, the law is really not in accordance to what we can do with what we have. If you have 2 terabytes of data, how do you go through all the thousands and hundreds and thousands or millions of emails to flag which ones are protected? So what we've been doing, and it's a bit outside of the law in itself, is that we also have a system of keywords. So the prosecutors use positive keywords, inclusive keywords. The defense puts in their exclusive keywords. And for the data, the electronic data, that's how we do it. And then at the end, the court verifies if what is there should be provided or not to the prosecutors, and then this is given to the prosecutors. And yes, there are many IT tools that can be put in place, like big organizations, to tag in advance what is protected. I think there is a bit, maybe to be controversial here, there is a bit two ways of seeing this. The more messy it is, and the less separation you have between what is protected and what is not in Switzerland, the longer this process is. So if you want the sorting process to last 15 years, because it can last 15 years if you have to go through millions of emails, then that's how you could do. But I would say that prosecutors don't have that much patience. So usually we try to find alternative ways, and we really recommend to put in place data. I mean, a data system that allows you to see more or less where is your protected and your privileged data within everything that they can take.
Thank you, Evin. Stéphane,
Yep.
I understand that you have to leave on an urgent basis, so thank you very much for joining us on the.
I'm very grateful. I do apologize, and thank you so much. Yep.
Nick, getting back to the US in terms of sorting data, I understand that contrary to Switzerland or the UK, this sorting is not automatic. It's one discovery begins, and how do you proceed in practice?
Yeah, it's a difficult one because you don't have a lot of rights when things are taken from you and during an active investigation. If you need something to go about to conduct your business, like if they take all your computers, that the government is required to give them back to you in short order after they make copies. But business records and things like that that are taken, often that can last a really long time. And to Evan's point, it takes a long time, even if they go through the full filter process like I talked about. The Americans have a lot of resources, probably compared to some of your jurisdictions, but most of those resources are focused on investigating cases. Nobody joins the FBI or the Department of Justice so they could look at privileged communications and decide if the government should have them or not, right? That's sort of a task that people are required to do with 10% of their time, and you can imagine they often don't want to use the 10% of their time doing that. So that bogs down and goes really slowly. Eve, your point's exactly right. So technically speaking, once they receive the documents, they should start the sorting right away, and then decide what they're going to share with the case team and what they're not. In practice, what ends up happening a lot is those documents, while maybe important to trial, are not as important in the decision of whether or not to bring a case and to charge somebody. Sort of the live witnesses and some key documents are. So what ends up happening is that sort of languishes and sits aside while the government decides if they're going to bring a case or not. And once they decide to bring the case and they actually have to turn over the discovery, that's when they're like, okay, this goes to the top of the list of the filter reviews. Oftentimes there's like a lot of them, but like the most important ones that are set for trial are the ones, and that's how it ends up happening. And they'll put more resources on it and go faster. But otherwise it sort of sits exactly like the way Evan said. There's a lot of filter reviews going on. Who knows how much is happening at a specific time. But if it's a big case, one that looks like charges are going to happen, that's when it can go a bit faster. One other note, something that Evan said, I'm having flashbacks to when I worked at the DOJ, and the prosecutors and the agents talk and say, okay, we think we should do a raid for these reasons. We think these particular pieces of evidence are at this location. Let's only get these small things. Let's like take 3 boxes maximum. And that way it'll be much easier to do the sorting. It'll be much easier to find the evidence. And then we won't just have like all this documents that nobody's ever gonna look at. And everyone's like, great, it sounds awesome. And then the raid happens and the agents come back and like, oh, how'd it go? Like, fantastic. I think we have everything we need and more. I'm like, great, how much stuff do you have? 87 boxes. It's like, sometimes the best laid plans sort of go sideways, and then you have to deal with it. Because I mean, I think, the one thing we're sort of all representing companies and individuals, but like, if you think of it from the prosecutor's perspective, like once you take it, you own it, right? So, and maybe they wish they didn't take it, but then once they do, they have to do all these things, and we can hold them accountable for it, right?
Can I ask a follow-up question on that, Nick? Why? Because I think that I'm a bit, maybe it's the movies and a bit the way we work. In all the US documents we have, it's just written in gigantic attorney-client privilege. It's just, there is always the mention. So is it really that if it's not written, then it's not protected? But it seems like even if it's written, there are things that they can see.
Yeah, so the reason why American law firms love writing privilege, sorry, my video died again, in massive letters, I'm making a huge sign with my hands right now, and put it everywhere, is for the reason with the process that I was talking about before, which is it's really hard to often tell something's privileged or not, but if it says it in huge letters at the top, then the person's like, okay, I should stop reading right now. So it's like a way to sort of make clear that that's privileged. And then if Evin, somehow that slips through the cracks, then it's pretty embarrassing that like you didn't catch this because it's in huge letters.
Okay.
And another reason why it's done, and this is probably the more practical reason, is in civil litigation in the US, obviously the discovery in the US is much more intrusive than it is in civil cases in most other jurisdictions. So documents have to be turned over, you know, to the other side in a civil litigation, even if they don't have them under the US discovery process. And obviously you don't want to turn over privileged documents anyway. So it's a way to sort of also sort of demonstrate that these documents should not be going to the other side in civil litigation. And then conversely, if something is accidentally turned over, if it says privilege in huge letters at the top, the other side is ethically required to stop reading and reach out and say, hey, I got this. Am I supposed to have it? Yes or no? So I think the civil component of that is just as important. And you know, lawyers, American lawyers are very risk averse, so we just write privilege in huge letters across everything, even in subject lines of emails, just in case, really.
Thank you. I think you've brought upon a very important issue regarding this is actually when do you know what the investigators have. So it's an issue of access to the file, and I think we could briefly discuss this because it really changes the way you can negotiate with the authorities depending on whether you know what has been taken or not. As is in the UK, there is this fundamental issue of that during the investigation you don't know and you don't really have access as long as you've not been indicted.
Yeah, I mean, during the investigation stage, what usually happens is that the investigators should leave a list of documents and items and data that they've taken. Usually that list is insufficient, it's very broad. In theory, you are allowed to ask for copies back of the documentation that's taken or the data that's taken. But in reality and in practice, you only ever get to know what has truly been taken if proceedings start. So if your client is charged with an offence, then I know it's a bit of a pain in the US to get discovery in criminal cases, whereas in the UK it's a right and it follows initial hearings and you get list of disclosure. And usually, what would happen in corporate crime cases, you know, you are usually given access to a platform or alternatively hard drives. But yeah, I mean, in terms of what they have actually taken, and if it's documentation that's privileged and you want it back, and there's an argument, there is a process before charge during the investigation stage where you can assert that right and litigate for the return of privileged material. So in general, pre-charge during the investigation stage, you do have an idea. In theory, you should be given a copy of some of the material, but you'll only ever find out if proceedings go further.
Thank you. In Switzerland, we should have a very early access to the investigation because as soon as you're a suspect, you normally have access to the file, and normally which can be delayed to the soonest after the first time you've been examined by the public prosecutors. But we have a worrying tendency of investigation being conducted against unknown persons whereas the persons are perfectly recognizable, but just so as to not grant access to the file to the person that is being investigated. Evin, can you a bit develop on how, because very often you won't even know that third parties have been raided, and you depend on those to inform you that they've been raided and that you should apply as a possible target of the investigation for the sealing. Evin.
Yeah, no, I mean, it's a very limited, unless you have good contact with the people that have been raided, and I think it's a good advice to give to everyone, which is be friends with everyone so that they tell you when they're raided. It's difficult to know, especially because the time frame in which you can ask for the seal, so the process that I asked before, is very short. So as soon as you've more or less learned that it has happened, you need to ask for the documents to be sealed, and then your status, I mean your interest with regards to yes or no, can you ask for the seal, is also restricted. So depending on that, you don't have much information. So I think that first of all, you don't, unless they haven't heard the suspect, they don't allow you to have access to the file. Then they take documents from people and then they don't inform you, and then you don't know, and you cannot ask for the documents to be protected. So there is a bit of this situation, especially with the big cases with the Office of the Attorney General of Switzerland, these big cases where at the end of the day, as a defense lawyer, you don't have much access to the case until very late in the game.
That also raises the issue of the quality of the dialogue between the defense lawyers and the prosecutors investigating in the matter, because at one point you may reach a sort of a deadlock due to the abundance of evidence. Nick, you've been on both sides of the of the bar. How do you deal with those issues in the US?
Yeah, it's an interesting one, and I think unlike some jurisdictions, the dialogue between the prosecutor and the lawyer representing either the company or the individual that's being investigated is encouraged. And oftentimes there are a lot of things that can be done sort of on an informal basis between the prosecutor and the lawyer. Essentially how the US works, there are hardline rules of what can and can't be done, but everything else is sort of policy. So the DOJ has a policy, and in their policies, there's always exceptions. So it really, really is, I don't want to say it's based on relationships, but if you have a good working relationship with the prosecutor, you're likely to be able to get them to exercise their discretion more than they would otherwise. So I think oftentimes in US cases, lawyers have to make a decision early on. Are they going to adopt a collaborative approach with the prosecutor in an effort to try to gain information that they otherwise wouldn't be entitled to? You know, if being cooperative is in the cards, like, you know, if you think that the prosecutors actually have it wrong, and there's a good chance that if you can sort of show them more than what they've heard from maybe one particular witness, that they may decide they actually don't have a case, then that might be the approach that makes sense. You know, otherwise, you know, maybe there's a case where it's very clear that they're going to file charges, and there may not be a lot to gain from adopting the collaborative approach because you know the charges are going to happen. So maybe in that case, it makes sense to be more aggressive and to go to the courts more on different issues, even if you're not sure it's actually going to be successful. So I think in the US, it's very strange, but some prosecutors will hold it against you and your client if you exercise your rights. If that makes sense, because you're making more work for them. So if you go to courts and ask for things that you think you're entitled to or a close call, the prosecutor may view that as, oh, you know, this person's being difficult, and they may be less inclined to sort of be collaborative with you. So, you know, it's a long way of saying there's no perfect answer to this. It's all sort of done on a case-by-case basis, and it really depends on sort of your strategic goals and what you're trying to get out of those discussions with the prosecutors, if that makes sense.
Okay. Aziz, what is the culture of dialogue in the UK generally, and agency by agency?
Yeah, I mean, if we're talking about the SFO, certainly I would encourage a collaborative approach. Unlike other enforcement agencies, at least with the SFO, you get to know the name of the lawyer and the investigators, and you get their email addresses and you can talk to them. And that's a stark difference to other enforcement agencies in the UK, where you're generally speaking to a wall. So I would say the culture when it comes to cases of this type is one of collaboration if you can, but of course it all depends on your client and the merits of your case, and the perhaps position that you hold as far as the evidence is concerned. But like I say, in the main, I think collaboration is to be encouraged. I don't think we're quite there yet, as it is in the US, where you would have perhaps a higher level of collaboration. I think we're probably mid-level at the moment. Yeah, so those are that's the culture in the US, in the UK.
Thank you, Aziz. Well, we're reaching the end of our webinar. So I just wanted to have a few takeaways. Basically, don't forget, either way, if you're the client or if you are the lawyer, that your correspondence or the advice that you give may find itself in another jurisdiction, and that entirely different rules may apply, and something you thought to be covered by professional secrecy or privilege will not be. So it's a bit difficult to imagine what may occur of your material, but I think it's very important in the advice you give to your clients to warn them of those possibilities, and again, not to disseminate information too much, because again, the cultures between our various jurisdictions are so different that something that could be obviously clear in one is obviously different in another, and whenever possible, try to consult in advance with foreign lawyers, just to make sure when you start correspondence with a group of lawyers representing various clients, think ahead. Do you need to establish a formal agreement to ensure protection? We haven't had time to address fully the issue of common privilege, common interest privilege, but again, in general, I think we could have spoken for hours, and we've just barely touched on the complexity of the topic. But again, the general advice is very careful with the communication with your clients, because it can end up being discovered in other jurisdictions. So I thank all our panelists for their intervention. I think again a very interesting topic, and I'm really thankful for the quality of your interventions. This webinar was recorded, so it's going to be accessible in the future. Dan?
Thank you very much, Yves, and thank you to our panel for being with us today. Truly a great webinar today, really interesting, some fantastic insights from you all. So thank you very much for joining us. Hope you all have a great rest of your day, and we can see you again soon. Goodbye.
Thanks for having us. Bye now.
Thank you very much.